Thank you for staying for the lunch and having the discussions. I overheard some of them, and I'm really glad that you've all had the opportunity to meet each other. And I encourage you to meet people that you haven't yet had a chance to chat with at the next break. In this first panel of the afternoon, we have two, and I'm going to call them absolutely wonderful lawyers. Both of whom I have a lot of respect for and have had the opportunity to interact with in various contexts. Our first speaker is Heather Mahony, and she's a partner with Woodward and Company, also in Victoria, and was a member of the litigation team in Tsilhqot'in and BC. Between 2002 and 2007, she gathered and presented oral history and forestry-related evidence at trial to meet the tests for Aboriginal title and infringement, and help draft the Tsilhqot'in trial closing arguments. No small feat, I imagine. Heather recently acted as counsel for an intervener in Keewatin at the Supreme Court of Canada, and she's a member of both the BC and Ontario bars. Her current practice is focused on representing her First Nations clients, including beneficiaries of Treaty 3, in seeking remedies for historic and ongoing injustices and reestablishing Indigenous governance. And I'll invite Heather up to speak and introduce Julie thereafter.
Thank you, Aimee. It is a real honor to be here. It's a little intimidating to be amidst such esteemed colleagues and to be here at the university, and what an honor. So today I'm going to be speaking about the importance of the evidentiary record in proof of Aboriginal title and non-title rights in Tsilhqot'in Nation and British Columbia. And like Kent, I'll make just a brief comment about pronunciation. I use Tsilhqot'in and Tsilhqot'in variously also in working with Tsilhqot'in elders. When they use the word, it doesn't sound much like either of those. So the Tsilhqot'in case has been described by some Indigenous scholars as one of the most significant court decisions in the world. Since here we are in Manitoba, some of you might be wondering, why is Tsilhqot'in important to First Nations in central Canada? The court's comments on interjurisdictional immunity obviously were elaborated on this morning, and the importance for those are clear. In addition, though, I'm advised that Aboriginal title claims are being made throughout Canada, including in Manitoba. Second, the character of treaty rights, like Aboriginal title and Aboriginal rights, are fact-specific, and I'll be talking a bit more about that. But that being the case, my comments about the importance of the evidentiary record are relevant not only to Aboriginal title and rights, but also to the characterization of treaty rights as well. And finally, the trial decision in Tsilhqot'in. The trial judge made some remarkable findings concerning unjustified infringement of Tsilhqot'in hunting and trapping rights, and there are potential implications. I believe there are potential implications for the enforcement of treaty harvesting rights as well. But first, I'm on the wrong slide. Sorry about that. First, a little bit of background. The Tsilhqot'in Nation is organized under the Indian Act into basically 6 bands, but from the Tsilhqot'in perspective, they're one nation. They share a common culture, territory, and history. The claim area itself is extremely remote. There was no road access into the valley until the 1970s, and to this day, the Keewatin community who lives in the claim area is off the hydroelectric grid. The genesis of the court case was the encroachment of commercial logging. while most of Tsilhqot'in territory had been heavily logged by the 1980s, the Tsilhqot'in trapline remained pristine. Oh, thank you. In 1983, BC granted a commercial logging license within the trapline. So the Tsilhqot'in started a court case in 1989, which began as a trapping rights case. Eventually, it was expanded to include an additional territory, the Brittany Triangle, as well as a claim of Aboriginal title to both the trapline and the Brittany Triangle. So fast forward 18 years to the trial decision, or 25 years to the Supreme Court of Canada's decision, and this was the outcome. On hunting and trapping rights, the trial court held that Tsilhqot'in people have an Aboriginal right to hunt and trap birds and animals throughout the claim area. This finding was not touched by the appeal courts, and this declaration stands. On Aboriginal title, the Supreme Court of Canada granted a declaration of Aboriginal title to a portion of the claim area that's approximately 2,000 square kilometers in size. The Supreme Court of Canada adopted and appended this map to its decision. The light green area is the claim area. Apparently I can use this pointer. Oh, there we go. The light green area is the claim area. So this was, the original action was the trapline territories that run sort of like this. This is the Brittany Triangle in between the Dasico and Tsilhqot'in rivers. This is the Namaya Valley here. So the light green area is the claim area, and the trial level court, Justice Vickers, granted a declaration of hunting and trapping rights over the entire area. And the declaration of Aboriginal title applies to that dark green area, which is bounded basically by Honey, the Namaya Valley in the south, and runs to Keewatin in the north and over to the Dasico River in the east, and to Tsilhqot'in Lake in the west. It's about 2,000 square kilometers, give or take. Now I'm going to talk a little bit about why the evidentiary record is so important in proving Section 35 rights. First of all the tests, Aboriginal title, non-title Aboriginal rights, and treaty rights are intensely fact-specific. So for example, Aboriginal title. As the Tsilhqot'in's legal team, we knew from Delgamuukw that we needed to prove exclusive use and occupation at sovereignty. After the Bernard and Marshall case, though, it was uncertain what types and intensity of occupation would be sufficient to ground that title, and what evidence would be sufficient to establish exclusivity. The Supreme Court of Canada in Tsilhqot'in has clarified that the sufficiency of occupation and exclusivity will depend on the Aboriginal group itself as well as the character of the land. So in a very real sense, the evidentiary record will shape proof and the extent of Aboriginal title. So there's no cookie-cutter approach to proving Aboriginal title. It really does depend on the group in question and the nature of the lands. The second reason why the evidence is so important is to get to the legal conclusion. The appellate courts will defer heavily to the trial judge's conclusions of fact. In the Tsilhqot'in case, it was a very long trial, spanned 5 years. To plaintiffs' legal counsel alone, 6 babies were born, including one of my own. That was just among counsel. An anecdote that really illustrates this point, I think, of deference to the trial judge. At the Supreme Court of Canada hearing in Tsilhqot'in, Justice, I think it was Justice Moldaver, it might have been Rothstein, I don't know, Robert can probably correct me, said to Canada's counsel, who was arguing against a declaration of title and that, sufficient occupation had not been established. He said, there's a mountain of evidence, as if to say, what more do you want? This was Rothstein, okay, thank you. Suggesting that if title couldn't be proven in this case on this evidence, it never could be. And I have to say that as one of the people whose life was, taken over for about a 6-year period in amassing this body of evidence, that was a very gratifying moment. So the final point about why the evidentiary record is important. I alluded to this earlier, the facts shape the law. And I'm going to give an example of, this court was the concept was really outlined by the court in Vanderpeet in an Aboriginal rights context, but equally it's been applied in a treaty rights context. And I think the decision in Sundown, this quote really illustrates that point. Treaty rights, like Aboriginal rights, are specific and may be exercised exclusively by the First Nation that signed the treaty. It's necessary to take into account the circumstances surrounding the signing of the treaty and the First Nations who later adhered to it. So consideration is to be given to the evidence of where the hunting and fishing was done and how the members of the First Nation carried out these activities. So, while we might say, well, treaty rights don't require proof, they are rights. That is true. But to characterize those rights and to figure out whether they've been infringed, requires characterizing the right. And to do so, you have to look at how the right is practiced by that First Nation itself. So hopefully I've persuaded you that the evidentiary record is important regardless of whether you're a treaty First Nation or a non-treaty First Nation. Now I'm going to talk about the evidentiary record in Tsilhqot'in and the evidence that we led to prove Tsilhqot'in title and rights. So these were the tests we were working with on Aboriginal title. We had to prove exclusive occupation prior to sovereignty, and as was elaborated in the Supreme Court of Canada's decision, occupation must be sufficient, continuous where present occupation is relied on, and exclusive. For Aboriginal rights, we needed to prove that the activity is an element of a practice, custom, or tradition originating in pre-contact time that is integral to the distinctive culture of the Aboriginal group claiming the right. So an important category of evidence that we led was oral history evidence. The legal framework for oral history evidence within the courts was laid out in Delgamuukw. Notwithstanding the challenges created by the use of oral histories, the courts recognized that the law of evidence must be adapted in order to accommodate oral history evidence and place it on an equal footing with other types of historical evidence that the courts are familiar with. We called 29 Tsilhqot'in witnesses. The Tsilhqot'in method of oral history transmission, it was different in character to the Gitsan's tradition, which was at issue in Delgamuukw. But the court took into account the Tsilhqot'in evidence. So we actually led evidence about how Tsilhqot'in oral history is related. And the court recognized that Tsilhqot'in people have a subtle and intricate system of cultural checks, including repetition, caution, and deference. The court established a threshold process for determining the admissibility of oral history evidence. So at the outset of each oral historian's testimony, we led evidence concerning personal information about the attributes of that witness and his or her ability to recount hearsay evidence of practices, events, customs, and traditions. We led evidence about the sources, so if they learned the stories from their grandmother, who was that grandmother, what was the grandmother's relationship to the land, whether that person had was respected among other members of the community. And no one like failed that that test. So all of the elders who testified went through that process. We employed in-court interpreters, word spellers, an illustrator who the elders would be explaining, say, a piece of technology like a fishing weir or what have you. We had an illustrator actually draw, and I have an example of that coming up, as well as a court cartographer for those elders who were able to mark a map. We had a giant base map on the wall and Mylar overlays, and court cartographer digitized that evidence. So Justice Vickers, in his decision, I think it's fair to say he did give independent weight to oral history, which was a clear rejection of the approach advocated by Canada's expert, Dr. von Gernot, whose view was that oral history should not be given independent weight without corroboration. And that's really apparent throughout his judgment. We also called experts in, you name it, we had a large range of experts. Historical documents, we had a very comprehensive historical record. Just to give you an idea of the magnitude of the documents in the trial, there were 600 exhibits entered. Exhibit 156 alone included over 1,000 historical documents. So I'm just going to give you sort of a rundown on the issues that we had to prove in proving Aboriginal title and the types of evidence we used to prove those various points. So Aboriginal title is a collective right, so it's necessary to identify the collective that holds the Aboriginal title both historically and today. The plaintiff claimed title on behalf of the Tsilhqot'in Nation. BC denied the existence of the Tsilhqot'in Nation as a legal or political entity in 1846, requiring us to lead evidence and prove who that proper title holder was. We led evidence of a shared language, shared customs, shared traditions, Tsilhqot'in laws, a shared history, a shared territory, and that internally people didn't make distinctions, Tsilhqot'in people didn't make distinctions over who could harvest, where any Tsilhqot'in person could make use of resources within the whole territory. The evidence we led included oral history. We had a linguistics expert as well as a legal historian. So proving occupation, sufficient occupation was a central question. It was, not certain at the time what constituted sufficient occupation, and we had this Bernard and Marshall cloud hanging over our head with, this concept of regular use of definite tracts of land, and the governments were arguing that title could only exist to salt licks and village sites, sites that were very intensely occupied, and we were advocating a more territorial approach to title. The court, in the end, clarified what constitutes sufficient occupation, and said that it will depend on the character of the land as well as the nature of the Aboriginal group. And like Robert said this morning, they arrived at something which was somewhere between the whole traditional territory on the one hand and the postage stamp approach advocated for by the province on the other. So we led evidence about the existence of a Tsilhqot'in territory. We had a historical geographer who mapped references to the territory, defensive boundaries. We also had extensive oral history about the existence of a shared territory, as well as ethnographic sources. Both anthropologists called at trial, as well as studies and reports that had been done over the years. We led evidence of place names, arguing that the very existence of place names and the abundance of them suggested a very long history of occupation. So we had extensive oral history identifying place names, marking them on a map, referring to their meaning, legends associated with them, all of that, resource use associated with particular areas. And we had expert anthropological evidence that suggested that that abundance of place names was associated with an occupation for a very long period of time. So this is the place names map. It's from our final argument at trial, and was adopted and included by the trial judge in the trial decision. I don't know if you can see very well, but there's a very large number of place names, and particularly if you sort of compare it with the area over which we were able to prove Aboriginal title, it's kind of like that. So matches up. Legends. We led oral history, tying legends specifically to landmarks within the claim area, and again indicating a time depth of occupation. We also had records. Ferrand had gathered Tsilhqot'in legends early in the 20th century, and so that formed part of the record as well. We prepared a legends map that kind of depicted graphically where within the claim area the legends referred to. I'm going to whip through these because I have some other things. I'm seeing the time, and I have some other things I'd like to say about the non-title rights. But suffice to say, we led evidence about village sites. Again, we had archaeologists and extensive oral history. This is an example of one of the illustrations. It's from the evidence of Mabel William, one of the elders, and we had an illustrator. This was a Tsilhqot'in, or a pit house, which she described living in with her grandmother. Regular use was established primarily on the oral history record. We had elders' testimony about their personal family ancestral use and the patterns of occupation through the seasonal round. We had anthropological evidence about that it wasn't sort of random and this random nomadic pattern, but there was a pattern, and both the oral history evidence and the anthropological evidence were consistent on that. We also had ethnobotanists and wildlife biologists speak to this as well. We argued that the network of trails also established occupation sufficient to ground title. Key sources for that were our historical geographer, oral history, as well as the historical documents referring to the trail network. Again, there's the trail map showing the trail network throughout the claim area, and this was compiled from both the oral history, the documentary, and the expert evidence. This is from our final argument. This one, carrying capacity, I actually laughed out loud when I read this quote from the Supreme Court of Canada decision. We called an expert who was a community ecological planner, and there was considerable debate among the legal team as to, so some of the lawyers were scratching their heads going, why are we calling this? Is this guy, flaky? Or he was from California. His name was Marcus Wackernagel. But in the end, it carried the day. There's only 400 people. There was only 400 Tsilhqot'ins in the claim area. However, his evidence was that the land was capable of only supporting 100 to 1,000 people. So the Supreme Court of Canada was convinced that in that light, even though it was a large area of land, that was really the carrying capacity of the land. So in that context, the occupation by those 400 people was sufficient to ground a claim of title. So I come back to this. The test is very fact-specific. We also led extensive evidence about Aboriginal laws. And we led evidence of laws on pretty much every aspect, from exclusivity and defending the territory to land tenure systems, laws governing land use, trespass, customary family use laws, general land laws, laws about, you name it, sustainability, not wasting resources, etc. I'm going to skip right over continuity. Exclusivity, I'll just touch on very briefly, although that was, something which was a big part of the evidence. We led evidence of defense of the territory, charging early fur traders rents and tolls, wars with other First Nations, to establish that the Tsilhqot'in defended their territory and considered it to be their own. Again, lots of evidence about laws. We had a historical, legal historian, Hamar Foster, who spoke to Tsilhqot'in laws about exclusivity, as well as extensive oral history evidence. Okay, in my last few minutes, I'm going to speak about the non-title rights. So I mentioned earlier that Justice Vickers, the trial judge, held that the Tsilhqot'in Nation had proven Aboriginal hunting and trapping rights. And I referred to his findings in this regard, particularly in relation to infringement of and the lack of justification for the infringement as remarkable. I truly believe they are, and I believe that his findings and the logic of his findings has implications beyond BC and for treaty rights people. Justice Vickers held that to recognize Aboriginal rights to hunt and trap over an area means that wildlife habitat must be managed to ensure a continuation of those rights. So I'd like you to, or I invite you to consider that statement in the context of the Mikisew test for, infringement of a treaty right, where, if the plaintiff, the claimant, can establish that no meaningful right remains, no meaningful ability to exercise the right remains, then a potential infringement action arises. We don't really know, as Robert said this morning, what the content of that is. What does it mean to have no meaningful ability to exercise the right? But I think there's some guidance to be had in the Tsilhqot'in case, the trial decision. Justice Vickers found that in the case of this Tsilhqot'in hunting and trapping rights, British Columbia had not developed a database that provided information on the individual species of wildlife or their numbers in the claim area. And the province had not conducted a needs analysis which would inform decision makers on the needs of the Tsilhqot'in people related to their hunting, trapping, and trading rights. And in the absence of that database and that needs analysis, he found that the Tsilhqot'in Aboriginal rights were not given priority. Well, for those of you that know the Sparrow test, you can guess where that's going. Justice Vickers held that justification requires, there's an onus on the Crown to develop sufficient credible information. And again, I'd like to just keep in the back of your mind that Mikisew meaningful right test. Vickers said, Tsilhqot'in Aboriginal rights to hunt and trap in the claim area must have some meaning. A management scheme that manages solely for maximizing timber values is no longer viable, where it has the potential to severely and unnecessarily impact Tsilhqot'in Aboriginal rights. To justify harvesting activities in the claim area, British Columbia must have sufficient credible information to allow a proper assessment of the impact on the wildlife in the area. In the absence of such information, forestry activities are an unjustified infringement. Which leads to the question, on this reasoning, is there a sustainable, does the Crown have an obligation in the presence of Aboriginal treaty rights to manage the land sustainably, and not just sustainably for the forest resource? He was highly critical of BC for not having an overarching approach to sustainability. So while there was a ministry that looked at the environment, there's a ministry that looked at land, there's a ministry that looked at wildlife, water, forestry, etc., there was no one sort of directing mind looking at, okay, when all of these activities are happening on the landscape, like what's the, I think of it in terms of cumulative effect. What's the cumulative effect on the exercise of the right? And that was fatal. So I don't know, you might say this is Obiter, or it's BC decision and it doesn't apply, but I think it's not binding or whatever. But I think that this is good fodder for lawyers in other provinces to run with. So the court in Keewatin basically adopted the Mikisew test, stating that not every taking up will constitute an infringement of the harvesting rights set out in Treaty 3. That said, if the taking up leaves no meaningful right to hunt, fish, or trap in relation to the territories over which they traditionally hunted, fished, or trapped, a potential action for treaty rights infringement will arise. So I think really this is the next frontier, is to really understand and give meaning to what does it mean to have no meaningful ability to exercise the right? Does it mean that, every last caribou has to be, there can't be a single caribou, or you don't have the right anymore? I mean, I don't think that can possibly be the correct interpretation. And again, it comes down to characterizing the right. What is that? What is the right? Is there a right to a harvestable surplus of species which people have traditionally hunted? If there's no ability to harvest commercially and the right has a commercial character, then notwithstanding that that Aboriginal group may be able to meet their sustenance needs, maybe the right has been rendered not meaningful for commercial purposes. So, arguably, to avoid unjustifiably infringing treaty harvesting rights, there's an onus on the Crown to have sufficient credible information to determine whether the meaningful exercise of the right may be sustained in the face of the development. So, there's a possibility that, if the claimant can establish that the Crown hasn't developed that information, then that may be sufficient to ground a claim for unjustified infringement. That's it. That's me. A much younger me. Speaking with Doris Lulua, who was the elder that I guess I'm most attached to and worked with for the longest, and who gave absolutely fabulous evidence in the trial. Sitting next to her is her sister, Madeline. Next to her is her cousin, Minnie Charlie Boy, who also was on the stand. Mini Charlie Boy was on the stand for literally weeks. I mean, you really got to hand it to these elders. They're amazing. They're just, so inspiring, and the stamina required. Sitting through night sittings. I mean, I was, taking naps in my office in the afternoon. We'd start in the morning and go all morning, take a break, hold a night sitting to accommodate the telling of a legend in accordance with protocols. And these elders were still going strong at 10 o'clock at night. So I guess I'll close on that note and just really that the success belongs to them.